audience, but I'm sure they're going to want every single word of our very quick chat. So I just saw the survey that people don't want regulation by enforcement, which is an excellent intro to our panel. This is something the Chamber is very focused on, that we've been asking for a lot of clarity for many years now, and we're not really getting anything specific in a rulemaking structure, but the SEC has definitely ramped up its enforcement action significantly, which you're all aware of. So we think it's very important to put our views on the record, and I'm joined today by two outstanding partners from two law firms who took the lead on two amicus briefs that we recently filed, one on the Ripple matter and one on the Wahi matter. So Lily, maybe I'll start with you. Can you walk through kind of the high points of our argument and why the case we felt needed our opinion added to the record?
Yep. No, definitely. Thank you, Annemarie, and thank you for the Chamber for having me here today. So the amicus brief that we filed in SEC versus Ripple was actually a follow-on to the brief that, on behalf of the Chamber, filed SEC versus Telegram, which was the first time the Chamber decided to weigh in on the issue of what is the legal precedent that the court needs to consider with the application of Wahi and any existing case law for primary offerings of digital assets. A lot of the same themes that was in the brief in Telegram was within the amicus brief in the Ripple case, as well as a few additional concepts. So the primary objective was to make sure the court, and it's the same court, the Southern District of New York, knows that the current state of the law, the Wahi test, applies to primary offerings of investment contracts, and to properly ensure the court understands the distinction between an investment contract and the subject of that investment contract. It's an important distinction both the Telegram brief and the Ripple brief, in that just because a digital asset is offered pursuant to an investment contract doesn't make the digital asset itself an investment contract. There's no legal precedent that would support that basis. And so that was one of the objectives of the amicus brief, to make the court aware of that distinction and ensure that the law is applied in the proper context when the court makes its decision in the SEC versus Ripple case. And just to follow on, in the Telegram case, the court actually, in its opinion, took that into consideration. It was extremely careful in drawing a distinction between the investment contract, is what it was deciding on, and did not go beyond that to provide any view on what law applies to the subject of that investment contract. So I think that was the first objective in the Ripple brief. The second was because the tokens at issue in the case, and the Ripple the Chamber did not weigh in on the XRP token or Ripple specifically in the facts of the case, but because the XRP token had been in the market for quite some time, it was important for the Chamber to also weigh in and remind the court that there is no case law that applies Wahi in the context of secondary transactions. And the Ripple case really is about primary offerings of the Ripple offerings and the XRP token, not about secondary, but it was important for the Chamber and its members to also remind the court, to the extent they go beyond, the decision goes beyond the primary offering and covers secondary, that Wahi does not necessarily apply. There's no law to support Wahi applying in the secondary. And so the court would need to either create new legal precedent, drawing upon existing bills that we cited in the brief that were pending at that time. This was late last year in various House and Senate as proposals, or wait and not decide the issue on secondaries to the extent they wanted to weigh in until there was actual regulations on this topic or congressional action on this topic. And that was also important from a policy perspective for the Chamber to remind the court of the implications of no legal precedent on the secondary.
Yeah, and in the context of Wahi, it was a very, very different fact pattern, right?
Yeah.
It was insiders at Coinbase who traded ahead of information around particular coins being listed. So why don't you give us an outline of that case and the highlights of our brief on the Wahi matter?
Yeah, sure. So the Wahi case is all about secondary market trading. It is an insider trading action that was brought by the SEC in federal court in Washington State. And absolutely, the Chamber makes a similar point in the Wahi case, which I think is really a big swing vis-a-vis the SEC's approach. And I just want to pause on that for a second. In previous cases, there was bickering and debate amongst the SEC and defendants with respect to whether a particular offering of digital assets satisfied the Howey test. And one of the things the Digital Chamber and others are doing right now is really questioning fundamentally whether the Howey test should be applied at all in the context of secondary market trading. So that point is being made for sure. But second, I think that the Wahi case is in some ways sort of a high watermark in terms of what the SEC is doing, because the issuers or allocators, the creators of the digital assets themselves, are not parties to the case. Coinbase, which is the digital asset exchange where the insider information was utilized to allegedly facilitate insider trading, was not a party to the case. Rather, individuals were parties to the case. And we spend a lot of time in that brief educating the court as to some of the collateral consequences from that tact that the SEC is taking. And ultimately, we think that the SEC's real core missions to protect the investing public, to ensure efficient and fair markets, are ill-served by the regulation by enforcement approach, because it really sows chaos in the marketplace and, ironically, we believe harms the very investors that the SEC is charged with protecting.
I think another thing that was really important to us from the Chamber's point of view about Wahi was what the DOJ originally brought the case against these parties. They pled guilty, and they are going to be responsible for their actions. And it was, in our view, I think, unnecessary for the SEC to bring a second case on the same fact pattern. The DOJ made no mention at all of the assets being securities. And then the SEC does an analysis about 9 coins, I think, right, that sort of said, here's why these 9 coins are securities. But what we thought was, I guess humorous is the wrong word. I don't know what the right word would be. But they put out a framework of 30-something factors to consider when you're deciding whether a specific digital asset is a security or a non-security asset. And they didn't utilize their own framework in their analysis of why they thought specific coins were securities.
Yeah, there's an impulse, which is good, to create fair and sensible regulation in the space. But a point that we really wanted to stress in the brief is that merely because we're taking the position that the SEC should not be regulating by enforcement as to whether these digital assets are securities, we're not taking the position that this marketplace should be entirely unregulated. The DOJ in the Wahi case has taken action. They did not take the position that it was securities fraud, right? It was more of a traditional fraud action. And there are many other federal and state agencies that are patrolling the space.
Do either of you have any updates on the status of either case? We're seeing a lot of motions to, dismiss and summary judgments, but what's the status of either case?
So I'll start with the Ripple case. It's been a while since the original motions for summary judgment were filed on September 13th of 2020, and the day after the motions were filed, the Chamber promptly filed its first amicus brief in that case. There are 11 other amicus briefs filed total in that case weighing in. Then the opposition briefs were filed towards the end of October, with final briefs going in at the beginning of December. We have yet to see a decision in the case on those motions for summary judgment. We've had a few other decisions in the case since then. One of them on March 6th, most recently, was a ruling on expert witnesses and expert witness testimony and who each party can allow. And that suggests, because of who the judge decided on certain experts to be allowed on certain issues of fact and elements of the Howey test, that most likely there will be some element where the judge will move the case to trial on issues of fact, given that there will be experts that they've approved to allow to testify in some of those elements of Howie. But that doesn't mean that there won't be other decisions through the judge's ruling that will decide issues of law in the interim. So that's kind of where it currently stands, but I think everyone's expecting a decision any day now, but that's been for quite some time. So we'll have to wait and see.
Yeah, with respect to the Wahi case, we're at an earlier phase of the litigation. We're at the motion to dismiss phase, and the chamber submitted an amicus brief in that case. An amicus brief is a friend of the court brief, and the court is under no obligation to accept the brief into the record. So you have to make a motion to have the court accept the brief. Just last week, the court accepted our amicus brief. It was filed yesterday evening. And interestingly, there are some other potential amici, including Coinbase, who have tried to file their own briefs to assist the court. And the judge there actually requested an explanation and supplemental briefing as to some of the other third parties as to why their briefs are not duplicative of the chamber's brief or the defendant's brief. So it remains an open question how many amicus briefs will be filed in that case, but fortunately for the chambers, ours has been accepted.
Yeah, we were really proud of that. And it was a great piece of work, both of them were, so we really appreciate your efforts. We're now seeing, as if the federal courts aren't enough, we're now seeing the state courts weighing in. For those of you who missed it, the New York AG brought a case against KuCoin a week or so ago, a little bit more than a week, that basically took the position that Ethereum's a security, but then also had analysis around commodity aspects. How are you advising your clients on how to sort of navigate this universe where you have an SEC chairman saying that Ethereum, after proof of stake, is probably a security, the chairman of the CFTC is saying it's definitely a commodity, the New York AG is saying maybe it's both? Like, how do we, absent the legislation that you mentioned that we've been all working on so hard for a long time, how do your clients navigate this? What's the advice you're giving them?
You want to start?
Yeah, I'll start. Certainly, the New York AG cases, both CoinEx and KuCoin, raise issues of securities law violations under the Martin Act, which is the New York State Securities Enforcement Act that the New York AG is enforcing in each of those cases. It ties in a new test that hasn't been discussed as much, called the Wallstein test, which is another test for an asset being a security under New York state law. It predated Howie and hasn't been used in a lot of cases for quite some time because Howie then came into existence in 1946. And so a lot of both state and federal courts concluded certain assets were securities under the investment contract test in Howie and Reeves. But these cases, or New York AG's complaints, allege that certain assets may be securities under the New York State Wallstein test as well as the Howie test. So really, in advising clients, we have to think about all the various tests, what assets themselves are securities, and think about what's going to happen from a preemption perspective if state court decides certain issues ahead of the federal courts. How each of those decisions in the courts will play out, I think will be important. And also, the interesting part about the New York AG's actions is there's intermingling of facts, and I think that's one of the critical issues of Howie that I have to struggle with in analyzing the test is, at what point in time do you look at the facts and circumstances and apply the test? So is it at the outset of an offering, determine if the offering is an investment contract? Is it a later date and time? Do you reapply? But there may not be a contract to which the test can be applied. And so it creates a lot of unknown and questions that we really need courts, regulators, legislature to answer to be able to properly advise clients.
The financial services regulatory environment in the United States is extremely complex, even for traditional financial institutions offering fairly traditional services. And what we see here is a turf war that's unfolded, not only on the federal level, but within all of the other jurisdictions, the states and territories that our clients need to be aware of. So in addition to what I said earlier about the collateral consequences of this tact of regulation by enforcement, I think one of the saddest and perhaps not commented upon consequences of that is I worry that the US will diminish its status as a leader in financial services regulation. A lot of jurisdictions look to what the United States does in terms of sensible and fair financial services regulation. But if we continue to move on this tack, I fear that businesses will continue to just throw their hands up and say, enough, we're going to geofence out US persons, we're going to operate offshore. And if that's the case, ironically, the United States will have less of an influence on how this space is regulated, and that would be a bad thing in my view.
We agree. We only have a couple minutes left, but the other brief that we weighed in on in this past year, we were a signer on to another trade organization's leadership brief on the Grayscale matter. For those of you who haven't read it, we did a very great piece of work, I think, last year, which was a deep dive across our membership into why the SEC is blocking a spot Bitcoin ETF. It's on our website. It's called the Crypto Conundrum. And so we signed on to this Amicus brief in support of the fact that the SEC seems to be acting in an arbitrary, capricious manner, which was the finding of our report. But Dan, do you have anything to add on kind of the status of that case? Because it's very interesting.
Yeah, I mean, well, there were oral arguments at the intermediate appellate court level, the DC Circuit, within the past few weeks. And it's notoriously difficult to read the tea leaves during oral arguments, but what I can say is that there were some tough questions that were posed to the SEC. I find it interesting that sort of from a separation of powers perspective, perhaps the courts here can be a last bastion where we see inaction at the moment from Congress and from the executive action that many believe could be detrimental to the industry. In Ripple, in the Grayscale matter, in Wahi, we may actually see a court that really asks the SEC to pump the brakes a little bit in terms of how they're behaving.
Sure.
Right.
If you haven't read that decision, I would not want to be an SEC enforcement attorney in that court on that matter. That was, I think, pretty embarrassing for the SEC. But any final thoughts from either of you on the state of play around SEC enforcement regulation by enforcement?
So one area, I think there's a lot of focus on what's going to happen in the courts, and it's going to take it could take years before there's decisions in the lower courts and it gets appealed or even goes up to Supreme Court in some of these cases potentially. But in the meantime, I certainly would encourage folks, and I bring a lot of clients proactively to continue the discussions with the SEC, the various divisions, the chair's office. There is traction being made on the registration path, and I think that is also a dual path to waiting for more clarity from the courts. And so I just wouldn't lose sight of that path, and continuing to have those discussions are important to show that the industry is supportive of a compliant path forward.
Agreed. Well, we're just at time. I want to thank you both for all the great work you've done for the Chamber, and thanks for the time for today. Yeah. Thanks, everybody.
Thank you.